gallery here today.
The defense also wanted to introduce polygraph results related to cousin Eddie and Alex Murdaugh. Defense attorney Dick Harpootlian dropped an absolute bombshell.
Eddie Smith, who, as we've already understood, was charged with a whole bunch of stuff, had a proffer agreement with the state, and the proffer agreement was conditioned on him passing a polygraph. And as Mr. Waters knows, in other words, he had a deal, and the deal was predicated on him passing a polygraph. This is a copy of the results of that polygraph. And the polygraph was, did you kill Paul and Maggie Murdoch? He failed it. And so they, relying on that, canceled his proffer agreement. Now, I'm not saying necessarily that's admissible on cross, but I am saying that it's an issue, not now, but much closer to trial, that we need to be able to litigate. And there may be others. We're going back through, I will tell you, Mr. Murdaugh passed a polygraph, flying colors. So the same
I will tell you, Mr. Murdaugh passed a polygraph, flying colors. Those 8 words were spoken in open court by a defense attorney who has practiced law for half a century. But the polygraph results were never admitted. The judge ruled them inadmissible.
Polygraph.
In the end, Judge McCaslin ruled the polygraph results are inadmissible. The jury will not hear about them.
I'm going to rule that the results of a polygraph examination are not admissible, as well as the defendant's willingness or refusal to submit to a polygraph. And I'm going to tell you now, there is to be no mention of a polygraph test before the jury. This ruling is based on counsel and case and the Palmer case. Should the defense seek to introduce any evidence or testimony or reference concerning a polygraph examination, you must notify the court and obtain a ruling outside of the presence of the jury, or risk this case being a mistrial.
So why lead with them? Because they tell you exactly how this hearing operated. What the jury will hear and what the jury will never hear are 2 completely different trials. And that gap is where the real story lives. Before we go deeper into what the documents actually show, make sure you're subscribed to Trial Theory Unsealed, because we don't just cover the story, we follow the evidence. Now, picture this. A state forensic lab receives shell casings from a murder scene in Allendale County. They run the extraction marks through their ballistic database. The machine finds a match. But the match is not just any cold case. It is the same signature the state says belongs to the weapon that killed Maggie Murdoch. That is not a
second. And Griffin wasn't done. He accused the state of not taking their disclosure obligations seriously.
We are aware that SLED has received tips, because we've received tips. We've not been provided any information about tips of whether it's reliable or not, identifying anyone else other than Alex Murdaugh participating in the murders. We've not received any information. Have they found the murder weapons? Have they found the murder weapons since the last trial? And there's related information underlying all of those. And so we don't think the state is taking their obligations seriously enough to find out what Brady materials out there has been developed and what Giglio material out there has been developed. And this is what we are aware of today, but we don't have the benefit, we don't have the ability to contact law enforcement and get this information.
That is a live wire running directly through the center of the state's entire prosecution theory. And according to the defense, the state never said a word about it. Let that sink in. 1 gun, 2 alleged murder scenes, 0 disclosure. The hearing began as procedural housekeeping.
But it quickly turned into a fight over secret deals, alleged police misconduct, and even a bombshell claim that the Murdoch murder weapons might be connected to another killing. Yes, you heard me right. I'll get to more on that in just a moment. But first, the hearing started with Alex Murdaugh's defense team accusing the state of possibly hiding evidence that could help Alex Murdaugh impeach state's witnesses.
As to secret agreements, there's a co-defendant in some cases, and then he's been charged separately. His name is Eddie Smith. Curtis Eddie Smith, who's a distant cousin of Mr. Murdaugh, was charged on November 2021, almost 5 years ago, of ab-hand, pointing and presenting, conspiracy, filing a false police report, and that's related to a roadside shooting that involved Mr. Murdaugh. Subsequently, in June of 2022, he was indicted by the state grand jury of 4 counts of money laundering, trafficking in meth, of other things. 4+ years have gone by, and those cases have not been disposed of. Every other case that we're aware of have been disposed of. And it begs the question, why not? Do they have a cooperation agreement with Mr. Smith? If so, what are those terms? He has been identified as a witness in this case since the last trial, well before the last trial. So we've got nothing on Mr. Smith. And if they have a deal, they're obligated to disclose it. If they have an understanding, they're obligated to disclose it, and we've never received it.
Discovery disputes, jury logistics, venue arguments. But within minutes, defense attorney Jim Griffin turned the room towards something far more volatile. He stood before Judge McCaslin and said the quiet part out loud. The lead prosecutor, Creighton Waters, sat across from him and claimed he had never heard of the Allendale connection. Not once, not from SLED, not from the Attorney General's office. His exact words were that he would be flabbergasted if such a match existed. But here's the problem. Flabbergasted is not a legal standard. Brady is.
As to tips, we provided a lot of that information before, but as I said, this case was tried, over 3.5 years ago. And so we are in the process of, correlating. Heck, I get emails from all over the world to this day, but we characterize or categorize those, and there will be any sort of information, no matter how fanciful and far-fetched, and that'll be provided to the defense as well. And so again, that, as you recognize and as we recognize, that obligation is ongoing. We take it seriously, and anything that has developed since that time, we will make sure to provide to that defense. We are constantly always doing discovery audits and discovery checks.
All right, well, tell me about the Allendale with
I'm sorry, Your Honor.
the murder weapons.
That's the first I've heard of that. I have never heard the first thing about that. If somebody told me that they had matched that to the murder weapon, not only the first call again I would be making would be to them, and the second call I'd be making would be to Your Honor. That is the first I've heard of that. I've never read the Fitz article. Certainly nobody at SLED, who I communicate with on a daily basis, has said, hey, Creighton, by the way, X happened. So I will certainly look into that, but I would be flabbergasted to find out that actually had happened and no one had advised this office of that.
Okay. All right.
And the defense was not asking for speculation. They were asking for shell casing analysis, extraction mark comparisons, chain of custody records, the kind of evidence that either exists or does not exist, the kind of evidence that does not disappear because a prosecutor has not read a local news report. This is the same gun used to kill Maggie Murdoch. That phrase should echo, because if the defense is right, then the state's entire ballistic narrative collapses. The prosecution argued at trial that the weapon was a family gun, a blackout rifle that never surfaced after the murders. But if that same weapon's ballistic fingerprint appears at another homicide in another county, then either the state's forensic method is unreliable, or the gun was not where the state claimed it was. Those are the only two options.
As far as the murder in Allendale with the murder weapons, you certainly raised my eyebrows on that.
Your Honor, throughout this case, Fitz News has been breaking stories that we were unaware of. And we can go through a long litany of that. But there was a podcast, there's a reference to what I just said to you.
Maybe you could forward that to Mr. Waters and let him look at it and see if there's anything to it.
But we would ask that they look into that.
and I'll be the first to say, Your Honor, is that I don't watch the podcasts and I don't read the blogs. I try to base what I'm doing on the evidence and not on speculation that's out there in the media. But I've never heard of that thing, and I will make inquiries. But it would blow my mind if something like that had happened in SLED and not call me. I communicate them daily. Their general counsel sitting here in the gallery
And
here.
that is the ticking clock moment. If a murder weapon can travel between crime scenes while the state insists it was never found, then what else has not been found? What other evidence has been sitting in a SLED evidence locker while a man sits in prison convicted on forensic testimony? This is not a cold case procedural. This is a live national security question about the integrity of state forensic infrastructure. Because if one lab can produce a false match or suppress a true one, then every conviction built on that lab's word is now on borrowed time. Now consider the parallel track. The defense also raised the name of Curtis Eddie Smith, distant cousin, charged in a roadside shooting, indicted on money laundering and trafficking. 4 years and counting with no resolution. The defense asked a simple question. Does Eddie Smith have a deal? The prosecutor said no. Flat denial. No cooperation agreement. No secret understanding.
First of all, I want to say we take our obligations very seriously.
I know you do.
And have never had a problem. This is the first they've raised these specific issues. They could have given me a call, and if I ever discovered anything of importance, they're the first people that I call, and that's always been our practice. As to Giglio, as to Eddie Smith, there is no cooperation agreement. I don't have any secret agreements. If I had any agreement with the individual, I would disclose that to him. They have all the witness statements. They have the state grand jury testimony. They've had every bit of information that we have on, and every bit of discovery that we have on Eddie Smith. And there are no secret agreements. And if I do ever engage in agreement with any witness, I will disclose that immediately to the defense. I understand that.
But then, defense attorney Dick Harpootlian stood up and produced something the state did not volunteer, a proffer agreement. Eddie Smith was offered a deal. The condition was that he pass a polygraph when asked if he killed Paul and Maggie Murdoch. He failed. The state then canceled the agreement. So technically, the prosecutor is telling the truth. There is no active deal. But the reason there is no deal is because Eddie Smith failed the very test the state set for him.
Had the last word.
It was a proffer agreement. In the proffer is, you're going to tell us stuff, and if you pass the polygraph, we can go to the next step, which would be perhaps giving him something for his testimony. They were using it as a screening device, no question about it. But he failed the polygraph, so he didn't get the deal. He's right, he doesn't have a deal as far as we know. And the reason he doesn't have a deal is he failed the polygraph.
That is the difference between a clean denial and a scrubbed record. The state did not lie, but the state also did not lead with the truth. And in a case where the lead investigator, David Owen, was named in a separate murder case dismissed for withholding exculpatory evidence, the pattern becomes harder to ignore.
SLED agent David Owen, the lead investigator in the Murdaugh case, who also happens to be a former SLED Agent of the Year recipient.
With regard to credibility issues of police, we are aware that Judge Roger Young dismissed a murder case, and the name of that case is State v. Michael Colucci, and he was indicted in 2015. In June of 2025, Colucci's attorneys filed a motion to dismiss the indictment, saying that the state withheld critical exculpatory evidence on the eve of jury selection. The motions identify David Owen, SLED agent David Owen, who was the lead case agent in this case, who after this case received SLED Agent of the Year award. Judge Young dismissed the Colucci case because of withholding of exculpatory evidence. We want to know what's in Mr. Owen's SLED agent, I think he's retired now, in his HR file. Was he reprimanded? Was he sanctioned? Were any steps taken as a result of the Colucci matter?
One investigator accused of burying evidence, one witness who failed a polygraph, one ballistic match that never reached the defense. Each item alone is a problem. Together, they form a structure, and that structure has a name: institutional drift. Institutional drift. The legal system is not built to admit when its own instruments fail. Polygraphs are inadmissible because courts know they are unreliable.
Claim.
The case law is very clear in South Carolina that polygraphs are a no-no, and that's because while they may be an investigative tool, the reliability of them is questionable. And of course, even the U.S. Department of Justice manual notes that it's not a lie detector. What it does is record physical responses that, in the subjective opinion of the examiner, may indicate deception, but that deception may or may not be related to concerns of guilt or innocence. And that's why the courts have always rejected those, in addition to the fact that they go to the heart of why we have courts and why we have juries, and that's, of course, for the ultimate determination of the truth of the matter. And so, obviously, from the state's perspective, if there's a polygraph issue or there's an interview that occurred after polygraph, we are rock solid to make sure that witness and that officer or whatever does not say the P word out loud, and that's just been the general rule. And and this is the way I do things, just like we did the financial evidence last time. We laid all our cards on the table, did a long, extensive hearing. There was no gotcha moments or anything like that, and we just asked for the same thing, that there be, just sort of an in-camera ruling and an instruction that the polygraph word is not to be mentioned because, again, it can be hard to unring the bell. Your Honor, just to correct one thing, there's never been any sort of deal with Eddie Smith. A proffer is not a deal. It says in big bold letters, this is not a cooperation agreement. It's only, essentially a first aid provision. Again, polygraphs can be an investigative tool, but I never base decisions on them. And frankly, in my experience, I found them to be wrong, or for people to indicate DI for other emotional reasons than them to be accurate. This is why they're not ever relied upon in court.
Yet the state used one to screen a potential witness. Ballistic matching is presented as forensic certainty, yet the same casings that convicted a man may now point to another crime scene entirely. These are not coincidences. These are the consequences of a system that protects its own conclusions over its own records. The final domino was the venue ruling. Judge McCaslin found that fewer than 1 in 7 prospective jurors in Colleton County could be qualified.
Clerk of Court Becky Hill messed with the jury, and Murdaugh's defense team is a little paranoid that something could happen with jury selection this time around.
We would ask that there be direct supervision by you of the issuance of the jury summons, how they're picked. There were huge questions, obviously, after we learned of the clerk's conduct about how certain people maybe got on the venire and others did not. She was apparently excusing people, we believe, and of course this litigation would help us, litigation that's on appeal of the Fourth Circuit, let us develop that. Her daughter appeared on the jury venire, and she, and I guess at the time, either I nor Mr. Waters thought that was unusual, but she was talking to both of us about how she makes a great juror. She talked to me, I know she talked to you. I'm not saying expecting that to happen again. We've got a new court, but in terms of summonsing jurors, there's a process. The Supreme Court, I found out later on, that there's a list. Actually, they're generated in Columbia, and then the clerk excuses before she issues, he or she issues those summons. There's a screening process. That's what I'm concerned about. In other words, the big list will come from Columbia, but how it gets narrowed down before we ever see it, that would be me and Mr. Waters, concerns me greatly.
Again, this is the first that I've heard of any issues with that. I mean, my understanding is with Judge Newman's supervision, obviously a number of ones that were excused based on patent exemptions, such as over 65 who claimed that were non-residency issues and that sort of thing.
Right. Would be my understanding of what normally happens
and when we
pick a jury here.
We had the whole panel arrive. Yes, there was something like that. Obviously, she was excused. There were also people that had close relationships with with Alex Murdaugh and the Murdaugh family. And of course, we vetted all of that and excused as appropriate.
Well, but what was never done, and I tried to get the list, compare the initial list that was generated in Columbia to what actually were summons that were issued. And certainly there were people that the clerk said,
they don't live here. They're over 65.
Dead, whatever. I get that. But if we never got the original list. So we don't know, and again, call me suspicious, but when we have evidence that the clerk of court is attempting to influence the jury to obtain a guilty verdict so she could sell more books, when did that start? Did it start when she started winnowing down people she thought might be helpful to us? And I'm not saying that could happen again, but I think I need to mention it. I need to say to the court, I never expected it to happen the first time. I've been doing this 50 years. I've never seen the clerk of court interfere in this process. And clearly, our Supreme Court found she did.
The clerk of court had already been found by the state Supreme Court to have tampered with the jury. The judge ruled that actual juror prejudice existed. The trial will move. But here is what did not move: the prosecution's obligation to disclose exculpatory evidence. That obligation follows the case wherever it goes, to Charleston or anywhere else. And if the Allendale ballistic match is real, then the prosecution cannot claim ignorance forever.
The defense won the change of venue motion.
I find that the defendant has satisfied his burden under State v. Manning, where he's demonstrated actual juror prejudice. And unlike the ordinary pretrial publicity case, the evidence before this court is based on the actual results of the voir dire conducted in this case in the January 2023 trial. Fewer than 1 in 7 prospective jurors were qualified to serve, demonstrating an extraordinary degree of community exposure and prejudice. Second, under Reamer versus U.S., the interference with the jury process by an officer of this court is deemed presumptively prejudicial and cannot be measured by any voir dire. Ultimately, the decision to change venue lies within the sound discretion of the trial court, providing that a showing of actual juror prejudice is made. This ruling rests on 4 grounds. First, the exceptional rate of juror disqualification during the January 23 jury selection. Second, the community prejudice arising from the size of the county and the long-standing association between the defendant's family and the 14th Circuit. Third, the South Carolina Supreme Court's determination that the former Colleton County Clerk of Court improperly influenced the jury, depriving the defendant of his constitutional right to an impartial jury. And fourth, the form of publicity surrounding this case. There's case law that says I can't transfer something just for publicity. That can be cured. But with the 4 grounds that I've just stated,
Here is what I want you to do. The defense referenced a specific ballistic analysis involving a .300 blackout rifle and shell casings from the Murdaugh crime scene. That analysis is referenced in court filings. Pull the motion to compel discovery filed in the Murdaugh Retrial. Read the section on ballistics. Then ask yourself one question. If the same gun was used in 2 murders and the state only disclosed 1, what else is sitting in a lab report waiting for someone to read it? If this video gave you one new detail worth sharing, pass it to one person who follows this case. Then like and subscribe to Trial Theory Unsealed. Turn on notifications, because the next filing will not wait for the news cycle, and neither will we.